Hello everyone, this is Brian Ka with another video to help you pass the California baby bar exam. If you've been watching my videos, I like to start out each video with a short story or other subjects that has to do with law school or the bar exam, and I hope that the stories that I share can and will help you do better in law school and eventually pass the baby bar exam and the general bar exam. So in this video, I wanted to share what are pros and cons of going to an online unaccredited law school. As you know, I'm not a typical student. I went to UC Davis, and after I graduated, I have done many things from music production, from DJing, running my own clothing line, running multiple businesses. But now I am focused on trying to finish law school and doing, several businesses, and I'm just working on them every day to make these businesses become successful. So instead of attending regular 3 year ABA law school, my life led me to this point where this unaccredited law school was the only way for me to become an attorney. Now, there are great things about going to an online law school, but there are also things that you should be aware of because these are very important things, especially if you're considering going to a non ABA unaccredited law school. I just wanted to share some of the things that you should keep in mind before deciding to take a leap forward and spend or sacrifice 4 years of your life into this and eventually becoming somebody who can lessen the pain, lessen the suffering, and help out people who can not legally represent themselves due to whether it be financial situation or language barrier, maybe they're not proficient in English or so forth. So let's start out with cons. If you go to, or if you decide to go to an unaccredited online law school, you cannot take, or you're not going to be eligible to take the bar exam in most of other states. It could be more than 50% now, but just for the sake of this argument, because I don't know the exact figure. I don't know if it's 25 states. I don't know if it's 28 states, but it's probably around there. You won't be eligible to take the bar exam in half of the states in America. What that means is if you attended an ABA school, all the other states will say, as long as you have done 4 years of or 3 years of law studies from an ABA accredited school, you are allowed to take the bar exam. And if you pass, you can become an attorney in that respective state. Now, for unaccredited, non ABA schools, such as the one that I'm attending, there are some states that'll allow you to sit for the bar exam, and there are some states that'll require you to be an attorney of good standing for, let's say, 5 to 7 years. And then they'll let you take the bar exam in that state. And I would say majority of states will not let you take the bar exam if you didn't go to an ABA law school. Now, this would depend on whether or not you want to end up practicing law in other states. But if you're only planning to stay in California, this shouldn't be a problem. Now, where you go to law school matters. And I'm not trying to belittle myself since I'm not going to an ABA law school, but it matters because, first of all, if you're trying to go to get a big law firm job, they're going to look at what law school you went to, unless you're already working for like a small or medium sized firm and you're like a paralegal there and you have been for the past 3 years and you tell them, okay, I'm going to do this thing called online law school. It's going to take me 4 years, possibly 5 or 6, because I have to take the bar exam and pass. Unless you have that kind of arrangement, it's probably going to be difficult for you to get a job in these big law firms because they have resumes from UCLA, USC, UC Davis, Berkeley, you name it, that they probably have resumes stacked up and they have a choice to choose anyone that they feel like will, spend 12 hours a day to do all these grueling work. So, in that regard, I'm just being honest and trying to tell you that yes, it does matter. Another thing, another situation in which it would matter whether or not you went to an ABA school or a prestigious law school is, let's say that you are involved in a lawsuit against somebody. You're representing your client, and throughout this lawsuit, let's say that you want them to pay for your work because you've won the case. Let's say that you've won the case. They try to appeal the case, and in order to defend that appeal, you have to spend a lot of time, a lot of effort, and you had to charge them, let's say, $200,000. You may say in the appeal on paper, saying that you went to Harvard and 6 other attorneys, they went to Yale, another one to North Carolina, another one went to another, University of Texas. And you wrote that to the judge. And the judge may say, okay, since you went to Harvard, since you went to University of Texas, since you went to Yale, you do deserve to get, $1,500 per hour. And whereas an attorney who went to a lesser school like mine deserves to get $300 an hour. And I know this sucks, but in real life, that's how they'll separate attorney billing hours by which law school they attended. And I don't think that this is a good way. I don't think that all judges would do this because there are brilliant lawyers who went to a lesser prestigious school and kicking ass, and maybe they're charging more than $1,500. But I gotta say that this could happen, and it's very unfair again, but it could happen. Let's see. I'm sure that you have seen plenty of people who went to a mediocre law school on YouTube saying that yes, where what law school you go, it does matter, and they tell you and bash you and tell you that you're not worth anything because you didn't go to a specific or prestigious law school. And this is something that you're just going to carry on your back for the rest of your life because once you make the decision to be the underdog, and I like being the underdog. I've always been the underdog. So I enjoy it. But if you're somebody who doesn't enjoy being the underdog, this is probably not the way for you. And I'm just being very blunt because what's the point of, you know, lying here? I want people who watch my videos to learn and get a ton of value by watching my videos. And there's nothing worse than coming out and telling you something that it's not. So I didn't mean to make you feel bad or feel any less because now I'm going to talk about some pros. Now, the first thing that I must say is that when I went to this law school 10 years ago, because I had a 10-year break due to life circumstances, hardships, you name it, I've been through it, still going through it. May not look like it, but I am. Um, 10 years ago, I think some of my classes, we had about like 9 or 10 students per professor. This trimester, we had about 17. And each day we had about 15, 16 because there would be like a student or two missing. So on average, about 15 students per professor. Now, if you really think about it, if you went to like UCLA Law School, it's like hundreds to a professor. And there's a chance that unless you go introduce yourself to these professors, they're not going to know you at all. Now, going to an unaccredited online law school like my law school, if you have 15 students per professor, your professor is going to know you inside and out. And I mean, you're going to be laughing, joking. On bad days, you're going to have to take, your professor's attitude sometimes. It's like very personal. Like think of it as like a tutoring session. It's not really a classroom per se. Like, in college, you had a political science 101 with 600 students per professor. It's not like that at all. So for 4 years, for each class, you're going to have basically a one-on-one session with prestigious. Just because my law school is unaccredited online law school doesn't mean the people who are teaching or the faculty are any less than prestigious ABA schools. Because we have current judge teaching, we have public defenders, we have people, actually more than one professor who worked for the State Bar of California for many years. We have actually two judges currently on the faculty role, and you're gonna be like really close with them. Like my recent professor just sent an email to everyone who's graduating in 2025 April, telling them, for those of you who are going to file a moral determination, I don't know exactly the name of it now, but they check your background basically, and you need two attorneys. You need to write two attorneys on that background check as reference. And she emailed these graduating students and said, feel free to use me or write my name down as one of your attorney references. And to me, that's awesome. And she knows everybody by name, and she knows exactly, or he knows exactly what your strengths are, weaknesses are, and they'll talk to you. And if you email them, they'll email you back right away. So we're talking like a tutoring session at a cost, a fraction of the cost of other ABA law schools, because my law school, I believe it's $36,000 for 4 years plus, some fees that they've added. I think that comes out to around like $2,000 to $3,000. So we're talking like, you know, less than $40,000 to get your JD. And, I think that's an incredible value if you leave out the fact that they're not ABA, or they're not, they don't have that moniker, attached, next to, their name. So that's a great thing that you should consider, especially if the way you learn is, or if you learn the best by communicating a lot with somebody, or your professors, or your fellow students. This is the way to go. So I talked about the nature of these classes. I talked about how close you'll be with these prestigious faculty members. I also talked about their tuition, which is substantially cheaper than, USC, or, other private institutions. And I know you're gonna look at like almost 150,000 to $200,000 of loan. And if you can make that much money after graduating, all powers to you. But there's always somebody out there who ends up finding out that this is not the way for them, what are you going to do with $150,000 of loan? You're going to have to pay that back. That could be a down payment for a house. Not in California anymore, but in Houston, you can still buy a really nice house for $250,000. So I want you to consider that. Let's see. Oh, and lastly, I went to a brick and mortar before, and I know how they teach the law. And they just, go through a bunch of cases. They call on you saying this is the Socratic method. But when it comes to passing the bar exam or the baby bar exam, they're not going to teach you anything. You just have to sort of get it. And if you didn't get it, you're going to fail. But one thing that I was very impressed, even in this trimester, is the fact that the professor was really thorough in going over exactly what you need to know to write for the bar exam. And she uploaded all these presentations for each legal theory that you had to memorize and know. And I know that from my previous brick and mortar experience, this is not usual. This is a very unusual thing. They assume that you don't know anything, whereas some other schools may assume that you should know this already. How the heck are you supposed to know how to study for these concepts, or know what concepts to memorize or study unless they tell you? But that's what other law schools do. So if you're like a slow learner like me, if you're somebody that wants to, you know, be very close with the faculty, maintain a very good relationship with them, kind of like, you know, you see them more than you see your family, once you start going to attending this law school. So, and lastly, I think that, I see students who show a lot of talent, even in my law school. And I see students that, I don't mean to bash, but it cannot even hold a conversation in English. And now I know that since California allows foreign attorneys to take the bar exam, you know, I personally know several people in my life who cannot converse in English language and hold talks, and I guess for the bar, state bar, being able to speak the language is not really a big concern to them. But, you know, what are you going to do if you had to represent a client and you had to go to court and you had to fight and you had to convince the jurors and you can't speak English, but you're a lawyer? To me, that's pretty surprising, but there are so many people like that out there. Whereas there are people who are already like 50 years old in my school and they're brilliant. I've met attorneys in my life, and just talking to these people, you can see that they have a very bright future ahead of them advocating for their clients. So even at my law school, there are people who are just, I don't know what they're doing. I guess they just want to have the license to practice, but they can't really represent clients, but they want to do it anyways. And there are also great people who show promises of becoming great attorneys. So, you know, it's not just like an average of people who you see that are going to succeed. It's a big fluctuation, even at my school. And I'm sure it's like that everywhere as well, you know. So I think it really depends on you. It really depends on what you want to get out of this law school marathon, you know. So I hope that this it became a 30-minute talk, but I hope this became a good resource for you, especially if you're somebody who's considering, non considering alternative law school, or trying to start this journey without, going to an ABA school. All right? So with that, let's start with 65. We're going to do 65 to 75, 10 questions. And after that, we're just going to have 25 more. So we'll be almost finished with this. So 65 says, Agent was an undercover police officer. Agent received information from a reliable source that Deft, recently released from prison after serving a sentence for selling narcotics, was again selling narcotics, but that he was being very cautious and would sell only to persons who knew a certain code word. Agent's source told Agent the current quote, code word. Agent approached Deft, offered to make a buy of narcotics, and sent the code word. Deft agreed to the sale and to the time and place of delivery. When Deft appeared with the narcotics, he was arrested. If Deft claims that he was entrapped, will he prevail on this issue? So, one thing about entrapment, and this is like the third time seeing this similar question, is that there are other elements within entrapment, but the most the element that they love to test is the predisposition element. And that is, if the person arguing using entrapment as defense, they cannot be predisposed to commit the crime, even if they were entrapped by a police officer. So, in this situation, was Deft predisposed to sell narcotics, right? Even if he was approached and entrapped by a police officer, or an agent. Well, they tell you that they had this code word, and he started selling, you know, on on the DL down low. But as long as somebody had this code word, he was willing to sell it, right? So he was predisposed to sell narcotics as long as somebody had the code word, correct? And that word predisposition, predisposed, comes out a lot whenever they test you on entrapment. And when you look at ABCD, the only answer choice that has the exact word predisposed is C. No, because theft was already predisposed to sell narcotics, right? He was going to sell narcotics anyways. He was already predisposed to sell narcotics. as long as somebody had his code word. Even if somebody had a code word and he wasn't gonna sell it, even if somebody had a code word, then he was not predisposed to sell narcotics to anyone who had the code word. But in this case, as long as you had the code word, he was predisposed to sell it. And if a defendant was predisposed to sell narcotics, he can't claim entrapment as defense. So C is the correct answer. Let's look at 66. Pete parked his car in a garage operated by Dunn. When Pete returned several hours later and demanded his car, Dunn could not produce the car because it had been stolen by a thief. If Pete asserts a claim against Dunn based on conversion, will Pete prevail? I don't really like conversion because the standard meaning when you write for the bar exam is for conversion. It's when a person has possession of somebody else's property and he substantially interfered with that, right? Now, in this question, first of all, Dunn was the person who operated the garage, right? And he took possession of Pete's car. And he had possession of the car, but this is not really a situation where somebody, substantially interfered with your right to possess an item by, let's say they said they were going to borrow your car and took possessory right, and instead of returning it as they promised, they decided to run away with it. That would be a standard conversion case. But here, there is a legal theory in which we have to kind of know is a theory of bailor and bailee. And that is when a bailor, who basically you go to a parking garage and give the valet your key, that establishes the bailor and bailee relationship. And not all the time, but according to most of the times, that bailee has a duty to return the car, sort of like a strict liability. But I don't like to say strict liability, but in that relationship of a bailor and a bailee, the bailee has to return the car. Otherwise, they would be committing conversion. And again, this is not the standard conversion case in which somebody had possessory right to another person's property and substantially interfered with that possessory right. That's not what happened here. But you just have to know that when there is a bailor and bailee relationship, sort of like a valet person taking the car to your garage, to their garage with your keys, and they must return the car in a same condition, right? So in this question, we have to look at A. If Pete asserts a claim against Dunn based on conversion, will Pete prevail? Well, yeah, prevail, but what's the reasoning? Yes, because Dunn could not produce Pete's car. Well, it's kind of obvious, but that seems okay, right? Yes, unless Pete recovers his car undamaged. uh, Pete recovering his car undamaged is not one of the elements that are required in a conversion case, right? Well, I guess substantial interference to the point where if the defendant had to basically give back the full amount, I guess that would apply. But here, it seems like A may be the better answer. No, C says no if done did not intentionally give custody of the car to the thief. And that's you may think that C could be right because conversion is an intentional tort, but again, I don't really like this question, but for this question, A is the right answer. D says no if Dunn had taken reasonable security precautions to prevent theft or parked cars. It sounds more like a negligence answer. So 66, the answer is A because Dunn could not produce Pete's car. And again, because of the Baylor and Bailey relationship, a conversion has been committed as long as Dunn was not able to produce the car because it had been stolen by a thief, even though that was probably an intervening causation which was unforeseeable when it comes to Baylor and Bailey relationship. It's sort of like a strict liability in which if the Bailey is not able to produce the car, then he would be liable for conversion. I think that's the best way to know this. So 67, Deft, while walking down a city street, found a wallet. Deft picked up the wallet and examined it. He found a driver's license giving the owner's name and address. However, Deft believed that the law was finders keepers, and he took out the cash in the wallet, put it in his pocket, and tossed the wallet into the trash can. Did Deft commit a theft crime? I really don't like this question either because they're asking you the elements of larceny is trespassory taking or carrying away another person's property with intent to permanently deprive of that person's property, right? So was there like a trespassory taking and carrying away? Well, here the theft picked up the wallet and examined it. That doesn't sound trespassory taking and carrying away. He just picked up the wallet and examined it. But the fact here says facts say he found a driver's license giving the owner's name and address. And I guess this is what makes it trespassory taking and carrying away another person's property, right? This little like one sentence saying that he found a driver's license and instead of giving the owner back knowing that it belonged to a person in the driver's license, that I guess satisfies the trespassory taking and carrying away, right? And then did he form the intent to permanently deprive of that person's property? Well, Death believed that the law was finders keepers, and that triggers automatically mistake of law defense. And that in this question, that is a trick question because then they tell you he took out the cash in the wallet, put it in his pocket, and tossed the wallet into the trash can, knowing that even though they're kind of hinting at mistake of the law and telling you that he may not have formed an intent to permanently deprive of another person's property. The fact that he saw the license, who owned the wallet, but depriving the owner of that property anyway, knowing who that wallet belonged to, is enough to charge him for the crime of larceny. And again, this is, I think it's a horrible question. And you can see that these MBE questions have been getting easier. It's still very, very confusing the way they word things, but it's gotten a lot easier, meaning the way they write it is more straightforward. And according to somebody who has gone over the recent Kaplan MBE exams, they said the wording is even more straightforward now. It's not these confusing, tricky questions anymore. So that are designed to throw you off and make you fail. But instead, I have heard that the wording of these MBE exams for the baby bar and the bar exam have gotten easier. So let's hope that it's not as tricky as the last two that we just reviewed. So 67A is the right answer. A child, a 4-year-old boy, accompanied mother to store. While mother was shopping in store, child wandered away. Child's hand was caught in an opening between the floor and an escalator in store. The escalator had been installed and designed and was maintained by ESCO. When Child's hand was caught, he cried out, and Walker, an employee of store, attempted to stop the escalator before Child was injured. Walker was unable to do so, and as a result, Child's hand was severely injured. Child, by an appropriate legal representative, has asserted claims against Store and ESCO. If the escalator was properly installed, designed, and maintained by ESCO, will child prevail against Store? Okay, it's kind of weird that they tell you that it was properly installed, designed, and maintained by ESCO. Means they're telling you, okay, leave out product liability. You know, product liability is not the answer here, but focus on child prevailing against store, meaning the child or the store, did they commit negligence? Did they have a duty? Yes. But did they breach that duty? And that is probably what the answer is going to be. It's going to mention something like, did they fail to exercise reasonable care? Meaning, did they breach their duty to act as a reasonable, prudent person under the same or similar circumstances? So 68, when you look at the answers, the store will not be liable as long as they exercised reasonable care in rescuing the child, right? But if they failed to exercise reasonable care in rescuing child, it means they breached their duty, right? Because they tell you the escalator was functioning correctly, it was designed and maintained, correctly. But if child sues the store, can the child and the legal representative prevail? And as you know, under negligence, they have a duty, but as long as they did not breach that duty, and of course, we have to cover causation and damages, but for the sake of this question, if they did not fail to exercise reasonable care in rescuing child, they would not be liable. So C is the right answer. 69. If Walker was unable to stop the escalator because the stop button was improperly designed, will child prevail against Esco on a claim based on? Okay, so there are three theories in which you can sue under the product liability, right? The first is the design defect, manufacturing defect, failure to warn. But one thing that, or two things that people usually miss is that you could also sue under the theory of negligence. And obviously, you're going to have to just prove the duty breach causation and damages. And third, you can sue under warranties. But in this question, they're asking you, can the child sue the manufacturer of the escalator under negligence? Yes. Under strict liability for defective product? Yes. Basically, a product liability. But can they sue under abnormally dangerous activity? And the answer is no, right? Abnormally dangerous activity is kind of like, you know, a construction team was working with a dynamite, or they were producing a chemical that basically burns your skin as soon as you touch it, and it leaked. You know, things like that are considered abnormally dangerous. But here we're talking about an escalator, right? So three is not the answer, but A and one and two are the answers. So B, one and two, but not three. Sorry that I didn't pull this up. Three, B would be the correct answer. If child was hemophiliac and either store or ESCO is found liable, will the child recover for additional expenses incurred in the treatment of his injuries because of this condition? All right, so the good old eggshell plaintiff rule, you shall find the victim as you find them, right? So if a child had a pre-existing condition and this condition was called hemophiliac, and if Store and ESCO were both liable, can child recover additional expenses even though he had this pre-existing condition? And the answer is yes, according to uh, eggshell plaintiff rule. You shall find the plaintiff as you find them, and as long as the expenses incurred as a from the pre-existing condition was reasonable, then the child may recover. So we see that A and B are yeses, so it's either A or B. A says yes if the additional expenses were reasonable in amount, and that is the answer. Yes, unless the additional expenses were covered by a collateral source, and that has nothing to do with being able to recover under this eggshell plaintiff rule. No, because the hemophilia was a pre-existing condition, and that contradicts what we just talked about. And D, no, if the liability of the defendant was based on strict liability and tort, and strict liability, I believe eggshell plaintiff rule will still apply. Just because it's not negligence, it's strict liability. What they're saying is it's not going to apply, but that is not the right answer, even if it's a cause of action brought under a strict liability claim. The eggshell plaintiff rule will still apply. All right, so let's look at 71. If child obtains a judgment against both store and esco, and store pays the judgment, may store compel esco to reimburse it for any part of the amount paid child. They're talking about indemnity and contribution, right? Well, they can, as long as, you know, according to this answer, they can ask for a contribution uh, as long as the store was not actively negligent. Now, if they were, actively negligent and they had a liability under that, then the store may not compel ESCO to reimburse it for any part of the amount because under, if the store pays the judgment and it compels, but if store had its own negligence case, then obviously, ESCO is not going to be liable to pay store's own negligence. But B is basically telling you that as long as they were not actively negligent and they had their own fault, own liability, then they may seek, right, or compel ESCO to pay the judgment. So here, B is the right answer. So 72, Mike, Leo, and Frank plan to rob the owner of a local liquor store. The understanding was that Mike would supply the guns and ammunition, and Leo and Frank would actually commit the robbery. Mike told Leo and Frank that all he wanted was to be paid for the guns and ammunition, that he would have nothing to do with the actual robbery and would not be present at the time or share in the proceeds. Mike supplied Leo and Frank with guns and ammunition, which they used to rob the owner of a liquor store. Can Mike be held criminally liable for the robbery of the owner of the liquor store as a co conspirator or an accessory before the fact? So, co conspirator theory is, well, first, conspiracy is two or more persons intending to commit the crime, and they in fact, made an agreement to commit the crime, right? And then, obviously, actions following that intent and agreement, right? Now, accomplice liability, accessory before the fact, would be aiding and abetting another person with intent to commit a felony or illegal act. So, as a co conspirator, he agreed, right, to supply ammunition and guns. And even if he didn't, or even if he told the other co conspirators that he would have nothing to do with the actual robbery, the rule is that any natural and probable consequences arising from the actual agreement to commit an illegal act, he would also be liable for all the crimes committed by the co-conspirators. I think this was Pinkerton's liability. I have to double check. It's been a while since I've done criminal law, but this is obvious that him not wanting to have anything to do with the actual robbery was not enough to withdraw himself from the actual conspiracy here. So he would be liable as a co-conspirator. Now, accessory before the fact, did he aid and abet? Yes, he did. Obviously, he was the one that supplied them with guns and ammunition, right? And when he did that, he had the intent or knew that they were going to rob a local liquor store. So yes, he would be liable under these two theories. So D would be the correct answer because D addresses both one and two and says both one and two, Mike will be criminally liable. All right, we just got three more. In order to get Art in trouble, Bob and Sam threatened him at gunpoint and told him, "If you do not immediately go into the bank and hold it up, we will kill you." Bob and Sam then positioned themselves so they could observe Art's conduct of the robbery. They gave Art a gun with one bullet. Art entered the bank and pointed the gun at a teller. Before Art received any money, he saw that the bank guard was about to shoot him, and Art dropped his gun and held up his hands in surrender. Did Art commit the crime of attempted robbery? Well, attempt is substantial step towards the commission of the crime, right? A substantial step. He did commit robbery or attempted robbery because you know, there was a substantial step towards the commission of the crime. He went in there and tried to rob the bank. So yes, and to be more precise, he entered the bank and pointed the gun at a teller, and that's substantial step towards the commission of the crime. And what's robbery? Robbery is taking and carrying away another person's property by threat or force, right? So it looks like there was attempted robbery. The question is, he was forced to do that, right? I cannot think of the defense right now. It's a really one of the easier defenses, but I'm having a. It's ah, I'll come back later, but it's when a person was threatened with loss of life or significant bodily harm, unless it's like a murder crime. Usually, he would be absolved of whatever crime he is charged with, right? So here, D repeats exactly what I just said. It says no because Art was threatened with the loss of his own life. Now, if he committed murder, that would be a different story because this is not usually a defense to serious crimes like murder. But even though attempted robbery is a serious crime, I think that because no persons died in this case, D would make sense. So did Art commit the crime of attempted robbery? No, because Art was threatened with the loss of his own life. Again, I know that I'm not pulling down these questions, and some of them you can't see it, but it's probably best practice for you to go to the link in the description. It's the baby bar exam question is all the way at the bottom of it. So make sure to download that and follow along these overview with the questions in front of you. I think that would be the best practice to get better at these instead of trying to figure out what I have on my screen. So 74, Lou went to the bank to close his account. The balance in the account was 50. Lou handed his passbook to the teller. The teller, misreading the figure of the passbook and in a computer printout purporting to show the balance in Lou's account, said, "Your balance is $500. Here is the $500." The teller gave Lou five $100 bills. Lou was aware of the mistake, but said nothing and left the bank with the $500. Did Lou commit the crime of obtaining property by false pretenses? Well, taking title using fraud or deceit, right? But if there's no fraud or deceit, there's no false pretenses. And C tells you misrepresentation, that's fraud. So if there's no misrepresentation here, right? Um, let's reread the facts. It was the teller who misread the figure and said, "Here is your 500." And there was no misrepresentation by Lou on his part in this fact pattern. So as long as he did not misrepresent, then there was no crime of obtaining property by false pretenses, right? And lastly, in 1979, county enacted a valid ordinance requiring that within 1 year from the date of enactment, all billboards had to be removed from property not zoned for commercial use. The ordinance provided for compensation to owners of billboards that were removed. ATCO maintained billboards on property in a rural area zoned exclusively for home use. Paul purchased a lot in the area. One of Atco's billboards blocked the view of a nearby lake from Paul's lot. Paul anticipated that the billboard would soon be removed and made plans to erect a modern ranch house on his lot. At the expiration of 1 year period, Atco had not removed the billboard. If Paul asserts a claim against Atco private based on nuisance, will Paul prevail? Well, for nuisance, it's basically a deprivation of your enjoyment and life right to enjoy your property, right? But for I forget whichever one it was. I forgot if it was private nuisance or public nuisance. I would have to look over the notes again. But one of them, the rule is that the damage that you suffered has to be unique. It needs to be special. And when I say special, it must be a type of damage in which you're uniquely suffered and other people didn't. That's what you need to prove. And for this question, D addresses the fact that Paul will prevail because Paul will suffer special harm. When they say special harm, that's what they mean. Harm that was different, unique from the rest of the society, basically. And because of that, D is the right answer. Yes, because Paul will suffer special harm from the continued maintenance of the billboard. I'm still thinking about that question 73. It's an easy word that I just can't get in on top of my head right now, but I'm sure it'll come back again. It's what happens if you're bombarded with so much law that you're memorizing. You sometimes forget the easiest things, and it won't come up, but the next day it will. Right? It's I'm still bothered by the fact that I can't remember it, but I'll make sure to come back to it later. All right. So that is 65 through 75. And lastly, I spoke to two commenters. They said that this is very helpful, and I'm so glad that uh, these videos are helpful to you. And if you have any questions about anything, make sure to just send me a message via comment boxes. And as long as I get a feeling that you're not a bot, I mean, you could be a bot, but gotta give benefit of the doubt and still treat you with respect, even if you are an AI. I'm gonna still try to be respectful unless you prove yourself to be a non-human. Then I'm gonna start ignoring your questions. But you know, giving you the benefit of the doubt and treat you with respect. So I answered your questions wholeheartedly. So if you have any other questions, make sure to leave them again in the chat boxes, comment boxes, and I'll try to get back to you as soon as I can. And thank you again for watching this video. And the next video, I'm not sure if I'm gonna do community property essay or finish this out, but either way, we're gonna do more of these questions so I can help you pass the baby bar exam, and we can both prepare for the general bar exam so we can both pass and help more people out there who are suffering and having a hard time from not being properly represented in this country. All right, thank you, and I'll see you next time.